Well, good afternoon. For those who don't know me, my name's Tim Gilmartin. I'm the president of the Gilmartin Group Real Estate Company and president of Sharevest Property Management Company. And I'm coming to you today with some very important information, which I haven't done in a long time, which is about the new rent control laws in the state of California. For those who don't know, and many of our clients have told me that they hadn't even heard this was happening, the governor of California signed a rent control law for the state, the entire state of California, into law on October 8th of this year. The law does become effective on January 1st of 2020, but it's important to note that rent increases are effective retroactive to March 15th of this year, 2019. The law limits annual rent increases. The law creates a just cause eviction limitation, and the law has certain notifications that you need to follow. So it's very important that we get this information out, especially today, because quite frankly, the dates are very important, and the date of the end of October is extremely important for what we're doing today. And that's exactly why I wanted to get it out. By the way, along with this video, if you request, there are notes, a PDF of a PowerPoint presentation, which each of the bullet points of what I'll be covering here. And this probably won't be more than 10 or 15 minutes long, but my goal is to get the information to you as quickly as I can. It just was passed 10 days ago. I'm not sure that we know everything about it. I'm not sure that I'm 100% correct on anything. If anybody sees anything or hears anything that I produced or present today that they think isn't correct, I'd love to hear from them so that we can make sure that the information is correct. I've read the law several times. One of the reasons I put together presentations like this is to make sure that I read the law. It kind of puts me under pressure. So the first thing to understand, there's three primary provisions of the rent control law. By the way, it's called the Tenant Act. What's it called? The Tenant Protection Act of 2019. I'm sorry, I wanted to make sure you knew the name of it. The Tenant Protection Act of 2019. Now, there's three primary provisions of this act. Provision number one, it limits the increase in rents on an annual basis. Number two, it limits the right to recover your units via eviction or just previous to now, just because you wanted to recover a unit, to just cause only. And number three, there's very specific noticing dates and notices that must be made to stay within the law. So if you have residential rental property, anything larger than a single family residence, this law applies to you. So the first issue that comes to mind or that we should discuss is the just cause unit recovery or just cause eviction laws. And there's two types of just cause evictions. Type number one is the at fault. And we all know what at fault just causes are. By the way, the problem with just cause is proving it in the court. And you actually sometimes can be forced to prove your cause in court, which, by the way, versus before today or before this law came into effect, for most cities without the state of California, if you wanted to recover your unit, it took 60 days notice only. There wasn't a reason needed. But now we have to have a reason. It has to be a just reason or a just cause. And of course, there's two types of causes: at fault causes and not fault or not at fault causes. Or no fault, causes. There's 11 at fault causes, or things like failure to pay your rent on time, failure to sign a new lease, breaking the law, all those types of things that would be normal. There's 11 of them, and I've attached that in Appendix A to this. There's 4 no fault just cause laws. Maybe the owner or the child of the owner or the grandparent of the owner has to be closely related, owner or family member can move into a unit as an owner-occupier of a unit. Single family residences that aren't owned by corporations, REITs, or LLCs with a corporate owner are exempted from this. But probably missed on that. The no faults would be if you want to recover it for rehabilitation and you need to rehab it, it's going to take more than 30 days. You can recover it. Be clear, just like in San Francisco where this goes on, sometimes you're forced to prove these types of things in front of a rent board. So it has to be real, it has to be permitted, it has to be not just paint. So there's 4 no-fault causes. There's 11 at-fault causes for your ability to recover your unit for eviction or just recovery. Now, this applies only to tenants, by the way, who have occupied the property for 12 months or longer. And one interesting rule is if a new adult comes into the lease within the first 12 months, then it's 24 months unless one person lived there for 12 months directly. Or it's a little bit, it's not exactly, can't tell you exactly in easy terms how that goes, but I've attached that in the appendix. Please read that closely because these causes are important. And this is one of the real issues. You see, rent control or rent limitations are of no value if you can just move a tenant out. So along with rent limitation comes just cause eviction. So this is how they protect the tenant from undue rent increases. By the way, the other thing, therefore, is the rent increases. You're allowed to increase your rent. You're allowed to increase your rent no more than twice in a 12-month period. But that total increase, whether it's once or twice, is limited to an annual amount. The annual amount limit right now, 5%, plus the regional increase in your consumer price index. And it's important to recognize regional because, San Francisco, Oakland, Hayward is one region. San Jose is a different region, actually. Los Angeles has its own regions. There's parts of California that don't actually have a regional CPI index. So it's important to know that for our area, the Bay Area here, my assumption is we're looking at the San Francisco, Oakland, Hayward CPI index for all urban consumers. If you don't have a regional index, then you're looking at the California All Urban Consumers Consumer Price Index. Now, interestingly, I had heard this several times. I was curious to know, well, what date? The date that we use is set starting April 1, 2019, and every April 1 going forward. By the way, this law does sunset in January of 2030, supposedly. We'll see if that happens. Until then, every April, whatever the CPI increase is, you can take that increase, add it to 5%. That's the maximum you can increase your rent. By the way, if the total adds more than 10%, then 10% is all you can get. So it's 10% max or CPI plus 5%, whichever is less. Okay. Bay Area rent increases for this year, as of March 15th, 2019, therefore are limited to 9%. That was 5% plus a 4% CPI increase April over April in the San Francisco, Oakland, Hayward CPI index, which, by the way, is about as strong as I've seen in several years for CPI increase. Good to note, all vacant units, when they come vacant, are then reset at the rate the owner wishes to set, or market rate, whatever it takes to get it rented. So vacant units are uncontrolled until rented. Once rented, of course, they go back into vacancy, or rent limitations or rent controls. There are several properties that are exempted from just cause eviction rules. Most of them that would affect you would be a single family residence, a rental home that you might own for a rental. That would be exempted from just cause. It's actually exempted also from the rent limitation laws, but you do have certain notification rules that you have to follow with that. And so to make sure that you have that ability to remove your tenants out. So the 9 property types are exempted, things like tourist hotels and transient hotels, hospitals and religious care facilities, dormitories and education facilities. If you own a home and you rent a room in your home, you're exempt from just cause eviction. You can ask the person to move. By the way, if you rent 3 rooms of your home and you have 3 different tenants, well, now you've given up that law. So don't rent more than 2 rooms to stay within this shared housing owner occupancy limit. A duplex that is owner occupied in 1 unit also is exempted from the just cause eviction rules, which is interesting. In San Francisco, it used to be 4 units owner occupied or less. By the way, that was all thrown out within several years after that came into effect. Also, properties whose certificate of occupancy is 15 years or less are exempted from this rule. But by the way, if your property is turning 15 this year, next year won't be exempt. In other words, every year you have to go back and look at whether your property is 15 years old or less. Now, let's be real, 99% of the property in our area is 50 years and older, so they're not likely to have a big impact. But it used to be, like in San Francisco, built before 1979, then they got it to 1986 and so on. Now the new statewide law, if it's less than 15 years, and as it rolls into older than 15 years, it becomes subject to the rules of just cause and rent limitations. Let's see, what else am I making sure I don't miss any of those? That's about the 9. I have that in notes. There's also 6 property types that are exempted from the rent increase limitation. So you can see the just cause limitations are slightly different than the rent increase limitations. And those are things like dormitories or at educational facilities. Of course, government stuff is never limited by any government rule. Housing that is already subject to local rent control ordinances, as long as the local ordinance is tougher than the state ordinance. This is a big point. Wherever there's a local ordinance that has a rent control law, as long as it's tougher than the statewide law, the local law controls. But if the statewide law is tougher than the local law, then the statewide law controls. In other words, the tenant wins regardless in this one. But that's what this is all about, saving the tenants. So housing that's already subject to local rent control laws may well be exempted because they probably already have tougher rent control laws, like, for instance, San Francisco. All single-family residences, again, are exempted from the rent limitations as long as they're not owned by a REIT, which is a real estate investment trust, a corporation, or an LLC, which is controlled by a corporation. Again, duplexes wherein the owner occupies one unit is exempt from rent limitations. Housing that's less than 15 years old is exempted from rent limitations. And already deed-restricted property that has housing for low, moderate, or very low-income housing, which already has its own restrictions in place. There are 3 very specific notifications and notification times that you need to pay attention to. The notifications have to do with notifying your tenants that you are exempt from just cause, or you're exempt from rent increase limitations. And by the way, all tenants have to be notified of the just cause and the rent limitation law that's now in effect. Now, these have very specific dates to them. If you have a tenant in place now, you don't actually have to notify them until they either renew their lease or August 1st of 2020. If you have new tenants, all new tenants starting with July 1st of 2020 have to have in their lease these 3 notices, or these notices, the notice of rent control, and if you're exempted, the notices of exemption, and they have to be signed off by the tenant. Those that are tenants already, you can just obviously do an addendum and send it out as part of the transaction. So again, there's 3 basic or specific notifications. These are important too, and possibly why you would want to have a property manager like our company to take care of your property, because you don't want to miss out on these deadlines and leave yourself exposed, especially if you own an exempt property. More than half of my clients actually own single-family residences as rentals, and so this is important that we make sure our notifications are correct on that. So again, when you look at the notes, you'll find that there's 3 basic notifications that you need to pay attention to. There's some very important dates and deadlines. Dates, deadlines, the same sort of thing. I like to make sure you pay attention, so I call them deadlines. The first one is March 15th of 2019. Well, you say, well, that already passed. You're right. I know the bill was signed October 8th, but the bill started March 15th. Don't ask me how that happens, but that's government for you. Retroactive date for rental increase limitation. So for instance, if you raised a tenant's rent March 16th or later, greater than 9%, you will need to adjust that rent on January 1st back to 9%. If you did greater than 9% and therefore they've paid you more than they should have since March 15th, that's okay. You actually do not owe a reimbursement for that either. You just have to correct it by January 1st. If, by the way, you didn't increase it by 9%, then the amount between 9% and the amount you raised, you would still have available to you up through March 15th of 2020. April 1st, 2019, very important date, and every April 1st thereafter. That's the annual CPI adjustment date for your region. So wherever you are, whenever it's time to look at your annual adjustment rate, by the way, when it comes to these types of things, I suggest that you therefore adjust your rent annually. You don't want to get caught behind. There is no such thing as baked rent increases for this law. In San Francisco, you may bank your rent increase. I'm a little concerned as to whether that might get kicked out with this new law because, whatever is worse for the owner usually is part of the new law, not the old law. But in San Francisco, it used to be if you didn't raise the rent for 3 years, each percentage that you didn't raise, you could add it all up and raise it in the 4th year. Well, in the state law, that's not allowed. If you don't raise it, you lose it. Use it or lose it. So April 1st of 2019, 20, 21, 22, right on through 2029, very important to track your annual CPI increase. October 31st. And the whole reason I wanted to make sure and get this information out today is the fact that October 31st is a very important day. This is the last day that you can give your tenants a 60-day notice to move without just cause. Now, I would warn you on this one because, of course, the government doesn't like people just showing up and kicking people out. So I would not go empty your entire building this week with a 60-day notice to happen at Christmas time of this year. That probably won't fly. I've heard of some already, news articles and so on, where tenants are standing up saying, hey, well, wait a minute, trying to get their local ordinance to start now versus start January 1st. So my suggestion is if you have a tenant that is always late, chronic problem, whatever it is, and you're thinking, maybe you'd like to get rid of that tenant, now is the time to consider and or do so. Starting with January 1st, they will have to have a cause, fault or no fault, in order to remove them. So if you have a tenant, I'm thinking of a building, we have a 14-unit property. My client, she says they have one tenant that's really been kind of a problem for them. We're just taking it over. That's probably 1 out of 14 that we will move in that property. The rest are fine. I found most owners don't like their tenants to move anyways. But if you happen to have one that's been a problem and then you've been thinking about doing it, October 31st is your last chance to give a 60-day notice without cause. Then there's January 1st, 2020. That's the actual effective date of the law. So all things have to be in operation as of January 20th, which means you need to start getting your contracts together, your notifications, and all those types of things. Your rent increases all start that date, so that if you've raised more than 9% since March 15th, you have to back it off by that day, so on and so forth. July 1st of 2020 is another big day. That's the days that you have to have your specific notices regarding exemptions for just cause, exemptions for rent limitations, and the actual law of the rent control law all have to be part of the notifications in your tenants' rental agreements by July 1st for new tenants, and then August 1st of 2020 for existing tenants. So some very specific dates and deadlines that you need to follow. Now, that's pretty much the law. Attached with my presentation here are all the notes to the presentation, the bullet points. I have an appendix with all the just causes. We're going to include actually a copy of the whole law. The good news is the law is only 10 pages long. Now, I'm here to warn you about the fact that this is not likely the last rent control law we're going to see in California. Matter of fact, I'd like to tell you, this is probably just the beginning of rent control laws in California. The history tells us that when government comes up with programs such as this, they tend to start up somewhat benign. They won't mind. And by the time they're done, they become very restrictive. And the statewide rent control law is only 10 pages long, in contrast to San Francisco's rent control ordinance, which is currently 152 pages long. In 1979, with CPI increasing at 11.3% over the past 12 months, San Francisco limited their rent increases to 7%. Kind of sounds like now, doesn't it? Although our CPI is only 4%. Imagine in 1979, CPI was 11.3. And by the way, that's after 4 or 5 years of 11-ish% and 3 more years of 10 and 11% CPI. But they were going to start at 10, and of course, they cut it to 7. It didn't take till 1984 when they added some more pages to their law and cut that rent increase to 4%. And then 8 years later, 1992, they cut it again to 60% of the CPI. So it went from 7% to 4%. To today, if CPI is 4%, then you get 60% of 4%, or a total of 2.4% as an increase in San Francisco. Of course, that means that San Francisco's rent control law is in operation for San Francisco because it's worse than the statewide rent control law. You understand? More things to understand. I brought this one up because we have exemptions for single-family residences and so on and so forth. When San Francisco started, they had exemptions for owner-occupied 4 units and less. Didn't take but about 5 years before they got rid of that one. And then all multi-unit properties were then under the law. Single-family residences were protected because at that time, Costa-Hawkins, which is the statewide rent control law prior to the current addition to the statewide rent control law, saved single-family residence owners from the rent control law. San Francisco also came up with a protected tenant status. In other words, here's the point. When we put in a law like this, the law just tends to get more and more onerous over time. I suspect that within 10 years, we won't have 10 pages. We'll be much closer to the 152 pages. Again, in San Francisco, you have protected tenant status. What does that mean, Tim? Well, that's very interesting. If you have a home with 2 or more units, tenant in there, you have 2 types of tenants, either by age or by health. If you have a tenant 60 years or older, or a tenant who is disabled, who's lived in their unit 10 years or longer, they're protected. They can never be moved. They have eviction protection. If you have a tenant that is catastrophically ill and has lived in their unit for 5 years or longer, they're protected and cannot be moved. You also have the local school teachers and students protected during the school year. In other words, you can see that every group will be protected sooner or later within the rent control law. And the idea is to make sure you pay attention. Why? Because if we don't pay attention, if we don't vote, if we don't deal with these types of things, the statewide rent control law will soon look like San Francisco. Berkeley, which got so bad, caused the Costa-Hawkins law. Because Berkeley used to say, even when a unit became vacant, you couldn't raise the rent beyond the annual increase based on the previous tenant's rent. Well, that's when Costa-Hawkins came along and said, hey, a vacant unit is uncontrolled. a single family residence is uncontrolled. And that changed things for Berkeley at that time. In other words, there is a place where these things push too far. How far are we going to let them push this time? I have some additional topics that we should be considering and discussing, and I'm sure that you're going to want to contact me about those topics. For instance, a couple of San Francisco's recent laws. COPA, C-O-P-A, the Community Opportunity to Purchase Act. This is specific to San Francisco, restricts the process when selling 3 or more units. What do you mean by that? If you own a 3-unit or more building in San Francisco and you want to sell it, you first must offer it to the Community Opportunity to Purchase Act group of nonprofits. And these nonprofits have the opportunity within 5 days to step up and say whether they would like to make an offer on the property or not. All who say they want to make an offer have 25 days to make an offer. You as an owner don't have to sell to them, but when you go back on the market for sale, if you sell to somebody else, you then have to offer it back to everybody who made you an offer. Obviously, you can say slow down the process, make the sale harder. That tends to make the price a bit lower. Other items, SB 329 just got passed also October 8th. This makes it unlawful to refuse Section 8 tenants. Well, I must say I have had several owners who did not want to have Section 8 tenants. I'm afraid that is no longer a viable deal. We'll have to come up with ways to make sure we qualify our tenants the way we want them, which means we have to have, if you're Section 8 but you have a high enough credit score, well, we're happy to have you, right? In other words, we can't use Section 8 as a qualifying tool because people were actually just straight out refusing them versus using their standard qualifying tools. The income for a Section 8 person now is only based on the portion they have to pay. Well, the government's never going to let them overpay based on their income, so that means they're already income qualified. And what was actually added to the law was that income qualification cannot be a discriminating factor. Very interesting. Other things to discuss, Costa-Hawkins. That's the statewide rent control law. That's the one we voted on to amend last year as a Proposition 10 in the state of California. As a matter of fact, the state of California population voted well over 60% against modifying Costa-Hawkins, and yet our governor, Gavin Newsom, signed the new law into effect and had asked for a new rent control law. So, in my opinion, I suppose that's why I misstate his name. I'm very disappointed. And lastly is the Ellis Act. That's probably your only real defense, and that is to say I quit the rental business while still owning the property. You can take your property off the rental market. Now, by the way, when you do that, you're going to have a certain set of rules about re-renting it, probably limited to sometime 5 to 10 years from now and so on and so forth. Not the best way to go, but of course, if you had a piece of property that you wanted to vacate so you could develop, rehab, or do something different with, Ellis Act might be your solution. If you want to tear a building down to build a bigger building or a different building, you have to use the Ellis Act in order to be able to do so. And that is still in effect. So the reality is that we have this new rent control law in the state of California called the Tenant Protection Act of 2019. It's underway now, folks. March 19th was the first date. April 1st, the second date. October 31st, the one that's 13 days in front of us now, is the next most important date. And then January 1st. What's about October 31st? It's your last chance to give a 60-day notice without cause. Again, be careful with that. This is only to be for those things who really have cause, but you don't have to prove it. If you want to just clear a building out, I'm pretty sure you'll get a notice from somebody saying, what did you do there? Are you trying to subvert the new Tenant Protection Act of 2019? So I say again, be careful. But again, if you have cause, but you haven't used the cause because you've just been lazy with it, time to get over the laziness and start to move the tenants that have given you cause out now. If you have any questions, love to hear from you. Email me, put the comments down below. I'm sure we'll post this on YouTube and so on. We'll be following that and answering and building on this conversation. Again, this is brand new, 10 days old, trying to get it as clear and clean as possible. If there's anybody out there who has questions or concerns or think maybe I misstated something, I'd love to hear from you and make sure that we're stating it correctly. Very nice to talk to you today. Happy property owning. Sharevest Property Management is ready to help you if you would like some help with your property in this new law environment. Give us a call. We're looking forward to hearing from you. Thanks.